Now we'll discuss the very suspension of fundamental rights and when there is the scope of writ jurisdiction and how under what circumstances fundamental rights are suspended show the very opportunity available under Article 32 of the Constitution could not be available, and as such Article 358 and 359 provide for suspension of fundamental rights during emergency as soon as the emergency is proclaimed on the ground of war or external aggression. All the freedoms guaranteed by Article 19 are automatically suspended. Article 358 makes it clear that in the case of issue of proclamation of emergency under Article 352, Article 19 shall not restrict the power of the state to make any law or to take any executive action abridging or taking away the fundamental rights guaranteed by Article 19 as soon as the proclamation of emergency ceases to operate. Article 19 is automatically revived and comes into effect, and the law made and the executive action taken during the said emergency shall be inoperative to the extent they are found inconsistent with the rights guaranteed by Article 19. However, the things done or omitted to be done during emergency cannot be challenged even after the emergency is over. It is to be noted that the provisions of Article 19 will be suspended upon the proclamation of emergency only when the proclamation of emergency is issued on the ground of war or external aggression, and not when the proclamation of emergency is issued on the ground of armed rebellion. The protection of Article 358 is available only to the laws enacted in relation to the emergency. Such law cannot be challenged on the ground of infringement of Article 19. This protection of Article 358 is also available to the ordinance made by the President or the Governor of a state during emergency. So Supreme Court has observed that the very expression things done or omitted to be done in Article 358 in the leading case, M.M. Pathak versus Union of India in 1978 expressed that it should be interpreted narrowly if it the law enacted before the proclamation of emergency is valid. It cannot be invalidated by the proclamation of emergency. Valid claims cannot be washed off merely by the proclamation of emergency. Such law may be suspended. by a law passed during the emergency if the law enacted prior to the proclamation of emergency has been valid, the proclamation of emergency would not invalidate it. The executive action which is not authorized by any law enacted by the competent legislature or the executive action which has been taken under a law which was enacted prior to proclamation of emergency and was invalid at the time of enactment is not protected under Article 358 and may be challenged on the ground of being violative of Article 19. Besides, the executive action, which is a continuance of the pre-emergency executive action, is not protected under Article 358. And now we'll go to the provisions of Article 359, and that is relating to suspension of the enforcement of fundamental rights during emergency. So, Article 359, where a proclamation of emergency is in operation, the President may declare that the right to move any court for the enforcement of such of the fundamental rights except Article 20 and 21 as may be mentioned in the order and all proceedings pending in any court for the enforcement of the rights so mentioned shall remain suspended for the period during which the proclamation of emergency is in force or for such certain period as may be specified in the order on the issue of the proclamation of emergency. The enforcement of the fundamental rights is not automatically suspended. Article 359 does not suspend any fundamental right, but it only authorizes the President to issue an order declaring that the right to move to the court for enforcement of such fundamental rights except Article 20 and 21 as may be mentioned in the order shall remain suspended. Thus, the enforcement of only such fundamental rights will be suspended as are specified in the order. The rights are not suspended, only their enforcement is suspended, and the enforcement is only suspended during the period of emergency or during such shorter period as has been specified in the order, and thereafter the rights so suspended may be enforced. It is to be noted that Article 359 does not empower the President to suspend the enforcement of Article 20 and 21. According to Clause 1A of Article 359, while such order mentioning any of the fundamental rights enforced by Part 3 of the Constitution except Article 2021 is in operation, nothing in that part confirming those rights shall restrict the power of the state as defined in this said part to make any law or to take any executive action while the state would put for the provisions contained in that part be competent to make or to take but any law so made shall to that extent of the incompetency ceases to have effect as soon as the said order before the law so ceases to have effect. However, where a proclamation of emergency is in operation only in any part of the territory of India, any such law may be made or any such executive action may be taken under Article 359 in relation to or in any state or union territory in which or any part of which the proclamation of emergency is not in operation, if and in so far as the security of India or any part of the territory therefore is threatened by activities in or in relation to that part of the territory of India in which the proclamation of emergency is in operation. So, while there is a proclamation of emergency under Article 352, the order of the President under Article 359 for suspending the enforcement of fundamental rights is not law within the meaning of Article 13, Clause 2, and therefore it cannot be challenged on the ground that it infringes any of the fundamental rights guaranteed by Part 3 of the Constitution. So, as there is a proclamation of emergency as provided under Article 352 of the Constitution on the ground of war or external aggression, the very fundamental rights provided under Article 19 is suspended as per the provisions of Article 358 and as to all other fundamental rights available under Part 3 except Article 20 and 21 could be suspended under an proclamation of national emergency as under Article 352 and all such fundamental rights contained in Part 3 of the Constitution except the fundamental rights provided under Article 20 and 21 could be suspended under Article 359. And so, regarding the very order of the President on proclamation of emergency, certain fundamental rights are being suspended within the territory of India. So, such fundamental rights, as we have discussed, as provided under Article 19, as suspended under Article 358, and all other fundamental rights except Article 20 and 21 are suspended under Article 359. So, any legislative action or executive action cannot be challenged under the writ jurisdiction of Article 32 as available under the Part 3 of the Constitution, and as Article 32 itself is a fundamental right, so it is being suspended under the proclamation of emergency or national emergency as provided under Article 352, and regarding the very suspension as it is mentioned under Article 359. So, in our upcoming video, we will discuss regarding the very writ jurisdiction of the high courts in India under Article 226.